Good afternoon. Welcome to the second of the three Quain Lectures in Jurisprudence of 2025, hosted by the UCL Faculty of Laws. I'm Kevin Toh, and I teach here at UCL Faculty of Laws, and along with my colleague Jeff King, sitting over there, I convene these lectures. This year, we are very fortunate to have as our Quain lecturer, Jeremy Waldon, who is undoubtedly one of the foremost legal and moral philosophers and also leading public intellectual of our time. Now, before I introduce Jeremy, I want to remind everyone that the third lecture will take place tomorrow late afternoon, 6 p.m., so we're going back to the late afternoon, evening hours, here in this room. And then on Friday, we will have a seminar in which three leading scholars, Mitch Berman, David Enoch, and Nina Versava, will comment on Jeremy's lectures, and Jeremy, in turn, will respond to them. There will also be a Q&A period, as there will be after today and after tomorrow evening's lecture. Okay? I hope you will join us in attending those events as well. Okay? Now, given that my colleague Jeff King has already given a substantial and splendid introduction to Jeremy, I will limit myself to just brief remarks. And I hope you will allow me to make an idiosyncratic and rather personal introduction. So Jeremy cannot possibly remember this, but my first time that I ever interacted with him was sometime in the mid-1990s when I was a law student at the University of Michigan. And I had just become the book review editor for the Michigan Law Review, which is a student-run journal. We had a book that we were sort of obliged to get reviewed because it was written by a member of the faculty at the University of Michigan. His name was William Miller, who was not really a lawyer but a historian. In particular, he was a historian of blood feuds, as they were depicted in the medieval Icelandic sagas. Miller had written a book called Humiliation that tried to discern the same kind of psychic economies that can be found among the characters in the sagas. We initially had some difficulty finding a reviewer who could relate Miller's book to law. After being turned down by a number of people, someone had a bright idea that we should approach Jeremy. We called him, which is what we did back then. He happened to be in his office at UC Berkeley, I believe, and he did not hesitate in accepting our invitation to review the book. A month or two hence, he sent us a draft of his review, and it was my job to edit the piece. It was the very first piece of Jeremy's writings that I had ever read, and I was struck by some qualities of the writer that still impressed me. His depth, his range, his courage, his curiosity, and his humanity. This last quality was especially notable, given that Miller had depicted in his book some nasty episodes of people humiliating each other with great cruelty. Jeremy discussed these episodes with insight, tact, and a perfectly pitched dismay and even outrage that really impressed me. I became a fan. Many of these qualities, I believe, are displayed in these Quain lectures, and I think we are very fortunate in being their first audience. So without further ado, I hope you will join me in welcoming him back to the lectern.
Thank you, Kevin. I have no memory of that at all. It's very good of you all to come here when you could be spending your lunch hour relaxing. I'll try and put you to sleep if I can. Because wasting time in Princeton one afternoon some years ago, I went into Labyrinth Books on Nassau Street. It's a lovely store. It's a little bit like Blackwell's in Oxford. It's with a fine selection of new and used volumes. You can browse there for hours, and there are comfortable chairs where you can read a few pages of your potential purchases. One book that caught my attention was a used copy of Principles of Roman Law by Fritz Scholz, a translation of the last set of lectures that Professor Scholz gave at the University of Berlin before the authorities there put an end to his teaching in 1933 on account of his Jewish ancestry. The book cost me $90, and I bought it. I have no idea why. To my shame, I have no training or professional interest in Roman law. But I was interested in principles, and I was intrigued by what I read Scholz saying at the very beginning of his lectures in a brief chapter called Explanatory Observations. So this is Professor Schultz. The title, Principles of Roman Law, calls for explanation. We do not intend to deal with the main elementary rules of Roman law. These may be called the principles of Roman law, but are generally known today as the elements of Roman law. Rather, we desire to elucidate the basic views of law and justice animating the Romans responsible for the law. It's from them that the rules of the Roman law system were derived. These are the true principia, the true beginnings of Roman law. And Professor Schultz went on. He said, it's not possible to arrive at these principles by the simple process of extracting them from available texts. The Romans didn't formulate them, self-analysis and research into underlying first principles being foreign to their nature. It may be assumed that in many cases they were not even aware of these principles. Nevertheless, it's not mere fantasy to presume their existence. The principles animating Roman jurists must necessarily be present in the results of their work and may be disclosed by means of research into the individual facts of Roman history. The principles that Schultz discussed in subsequent chapters were given minimal labels: statute law, their attitude towards legislation; simplicity, their attitude towards legal complexes; authority; security; nation; liberty; humanity; and fidelity. These were cashed out in more extensive formulations such as these. Liberty. They, the Romans, considered their strivings after liberty to be a national peculiarity. All other nations could, in their opinion, endure a state of servitude, but not the Roman nation. Or here's his observation on the principle of tradition. Seriously and cheerfully, they abide by the customs of their fathers. They refer to them often, and they feel themselves safe and sheltered when they adhere to them. To deviate from them is objectionable, and novarum rerum cupidus is to Roman ears what almost synonymous with revolutionary, novarum rerum cupidus being desirous of new things. Such observations were presented as the insights of an observer telling us about the character of Roman law, rather than as normative resources to be used by lawyers or magistrates internally in the workings of the legal system to address the problems that the system had to deal with. We might say that they purported to capture the spirit of Roman law, though if we said that, we might still be edging towards the view that a good Roman lawyer would need some awareness of these principles in order to do his job. They would need to animate him at least half-consciously. For sometimes the spirit of the law can be invoked as an element in legal argumentation. Well, Schultz's principles tell us about the character of the legal system he is studying. So I'm going to label them characterizing principles, contrasting them with principles that are understood to serve a normative function in the law, normative principles. Characterizing principles, normative principles. Now that makes it sound as though some principles are straightforwardly normative. We shall see in a few minutes that few modern jurists think there are any principles that are straightforwardly normative. Most think that what I'm calling normative principles are normative in a complicated and perhaps attenuated sense, and this is what I want to explore in this afternoon's lecture. I'm assuming that the principle that we discussed on Monday, the wrongdoing principle in Riggs against Palmer, was a normative principle in some relatively straightforward sense. Said that the New York Court of Appeals, Mr. Palmer was not to be permitted to gain property by his own wrongdoing. He is to be denied the inheritance that he purported to secure by murdering his grandfather. But I can imagine throwing this apparently straightforward distinction between characterizing principles like Schultz's principles and normative principles like the one I've just mentioned. I can imagine throwing this distinction into doubt by saying about the law of New York that its spirit is opposed to allowing anyone to secure property by their own wrongdoing. That descriptively, this is one of the characteristics of the legal system there, leaving it as a further question what norms or processes it deploys to actually block that from happening. And that begins to make the principle from Riggs and Palmer sound a little bit more like one of Schultz's characterizing principles. Once we start down this road, non-normativity becomes visible everywhere in law. According to Joseph Raz, laws which are not norms are a most important category of laws. They have been neglected, he says, by most legal philosophers. Okay, we're trying to remedy that neglect. Some of the laws which are not norms are often referred to as principles. For Raz, the main thing about principles was their abstraction that on his account was more mnemonic than conceptual. We often have need to refer summarily to a body of legal rules without specifying their content in detail. These references usually take the form of a statement of a principle, but they are not statements of the content of laws of a special type, namely legal principles. They are merely a brief allusion to a number or a cluster of rules. The idea of identifying principles of this kind is to see that even though a legal system comprises an immense amount of material, it's both practical and worthwhile to characterize it in terms of clumps of related ideas. A legal system is not just one damn thing after another, if that means enacted laws of rules of positive law which may be interpreted and applied, each of them one by one, without any reference to any of the others. Strands of commonality, strands of coherence can be discerned, and they can be cited at a level of abstraction that enables us to talk about the overall spirit or the identity of this area of law. And for comparative purposes, the discernment of principles of this sort may very well help us to distinguish the spirit of one kind of legal system from the spirit of another. One thing I'd like to do this afternoon is to consider whether there is any continuum between the evidently non-normative character of characterizing principles and the non-straightforwardness of the normativity of principles that we have no choice but to describe as normative. I think these two ideas might come closer together. We can work at that from both ends. Is there anything in the non-normativity of characterizing principles that should call our normative use of normative principles into question? Or is there any complexity in the normativity of what we're initially inclined to call normative principles that makes them seem in some respects like characterizing ideas? Such complexity might involve, for example, a distinction between classes of individuals, whose conduct the principle addresses. A given principle might be intended to be normative for one class of addressees and not another. It may be an instance of what Meyer Dan Cohen, former colleague of mine at Berkeley, has called the phenomenon of acoustic separation. For example, the law might tell officials what conduct to excuse without purporting to guide non-official action into that category. Yeah? The excuse of insanity is not supposed to guide you how to make yourself mad or why to make yourself mad. It's supposed to guide officials into the response to a certain type of case. So it's normative in one direction, it's not normative in another direction, or less normative in another direction. So we may want to look carefully at the normativity that a given principle offers in case it has something in common with principles that are avowedly non-normative. And we may have to acknowledge a sort of spectrum between normative and non-normative, or an array of spectrums as we consider different ways in which normativity may be compromised. So that's very dry, but that's really what I want to do this afternoon. Sticking with Fritz Scholz's work for a moment, we might want to treat his use of the term principles as being similar to that of Montesquieu in The Spirit of the Laws, written almost 200 years earlier. For Montesquieu, as I'm sure you all know, for Montesquieu there were different kinds of political systems: democracies, aristocracies, monarchies, and despotisms. These could be defined in terms of their structural nature: rule by one, rule by a few, rule by the many. But the principle of a political system, according to Montesquieu, is something like its driving force, what makes it tick, like the mainspring of a watch. So he says, for example, that virtue is the principle of democracy, honor is the principle of monarchy, and fear and terror are the principles of despotism. How does one come up with a set of characterizing principles like these? I guess it's a matter of study and interpretation. As Scholz pointed out, they're not disclosed directly in the text of a legal system, but still pondering those texts may lead us to certain conclusions, more general than the texts themselves, about what those who authored them were up to. That pondering may be organized, for example, in a functionalist way. If we think theoretically of the functions that law serves, then we will try to answer questions about the way that a given legal system endeavors to serve these functions. And that may be the basis, or a clue at least, to our attribution of certain characterizing principles. The point is to go beyond particular solutions to a more holistic view, if that is possible, to try to sum up the spirit of the legal system as a whole in the pithy form of a characterizing principle. Now listen, although a characterizing principle is holistic, it's not usually monistic. Although it's holistic, it's not usually monistic, as though there were but a single characterizing principle for each legal system. Montesquieu indeed talked as though that were the case, but Schultz thought there were several principles characterizing Roman law. His chapters dealt with 11 of them, and he readily conceded the incompleteness of his list. Most jurists are with Schultz on this. They discern a plurality, often a large number of characterizing principles that one can describe, one can invoke to describe a given system of law. And often those principles point in different directions. Also, legal systems change. Do the principles that characterize them change with them? Schultz says, yes, certainly. They are, of course, subject to the law of change. They, too, have a history. True, a set of principles that characterize the law of system L may change not only as L changes, but also as understandings of L change and become either more simple or more sophisticated or just point in different directions. Part of that history is going to be a matter of conflict between various principles or candidate principles. For some of them compete to characterize the same area of law. That conflict would be a problem if we were talking about normative principles, because it would introduce conflict and trade-offs into the picture we're trying to explore. But it may not matter for Schultz's characterizing principles. The main point of a characterizing principle is to tell us what a legal system is like. It doesn't offer us guidance about how to work within it. Whether it comprises one principle or many, we assume that it's the theorist's task to find a characterization that fits the legal system he is studying. Should we regard this as a straightforward enterprise? I wonder. It may make sense as such when we're considering relatively non-pluralistic societies, like Schultz's Rome, or France and Persia in Montesquieu's time, each organized in its own way around its own legal monoculture. But what about societies like our own 21st century European states, or 20th and 21st century America, which on any plausible account are riven by deep and conflicting partisan values? How do we go about, on this picture, how do we go about characterizing the brokenness or the dividedness of the legal system? For example, scholars in the critical legal studies movement, crits, I shall call them affectionately, became convinced in the 1970s that modern legal systems are characterized by warring principles of individualism on the one hand, or some suitably invigorating version thereof, which seeks to leave each person's fate in their own hands, and on the other hand, a craving for the shelter of community and solidarity, where we look out for each other and accept that our individual fates are importantly linked together. They thought that there were elements of both of those in the ethos and the spirit of the legal system. The crits used to say that if you examine our doctrines of private law, torts, contracts, and so on, you'll find these principles of individuality, individualism, and solidarity at war with one another. Caveat emptor on the one hand versus doctrines of unconscionability on the other hand, marshalling support for what seem to be inconsistent outcomes, depending on which of these tendencies happens to be uppermost in the mind of any particular adjudicator on any particular day. Here's what Duncan Kennedy, the leading crit, inferred from these inconsistencies. The acknowledgement of contradiction makes it easier to understand judicial behavior that offends the ideal of the judge as a supremely rational being. The judge cannot, any more than the analyst, avoid the moment of truth in which one simply shifts modes from a sort of individualistic mode to a solidaristic mode. When the judge cannot avoid the moment of truth in which one simply shifts modes. In place of the apparatus of rule-making and rule application, we come suddenly upon a gap, a balancing test, a good faith standard, a fake or incoherent rule, or the enthusiastic adoption of a train of reasoning that we all know will be ignored in the next case. It just depends on which neurons fire in the judge's brain. If these deep background principles were conceived just as normative, then it would have to be said on the CLS account, and many of the crits said this, that the body of our law is so riven with contradiction as to be capable of offering spurious support for everything and decisive support for nothing in legal reasoning, which, as those of you who were here on Tuesday will remember was, on Monday, will remember was more or less what I said. I know that when analytic legal philosophers mention the crits, critical legal studies, they're supposed to then machine gun the position. But I would not do that for the world. We've achieved a lot of insight from critical legal studies. The argument can be generalized, for it's not just about normative contradictions in Duncan Kennedy's extreme sense. A similar conclusion follows even if we acknowledge a plurality of smaller scale ideals, partly conflicting, partly complementary ideas, jostling and competing in each system for the same principled space. It's somewhat similar to what Raz said, and I quoted him on Monday. There may be no difficulty in identifying a given principle embedded in the body of that law, but if we use just that principle in legal argument in favour of a decision for one side or another, we're not really being faithful, actually, to the reality of the principled character of the law. For our law comprises not just this one principle, but a mélange of other principles, jostling with it in ways that leave us quite unclear what the actual bearing of all of them on future cases should be taken to be. Since, and this is another crit, Roberto Unger, since, as Unger put it, law is a product of real collective conflict carried on over a long time among many different wills and imaginations, many different interests and visions. Therefore, any given body of legal doctrine is bound to be messy, rich in compromises and contradictions. Warring solutions, said Unger, to similar problems will exist. Their boundaries of application will remain uncertain. Interests and ideals favoured in some domains will be discounted in others for no better reason than the sequence in which certain decisive conflicts took place and the relative influence enjoyed by contending portions of opinion at the time. Intellectual fashions will join with preponderant interests to produce results that neither interests nor fashions alone would have allowed us to predict. Defeated or rejected solutions will remain incongruously in the corners of the law as vestiges of past approaches. All of this, as I say, is problematic on a normative understanding of the work that principles are supposed to do to solve cases. All of this is problematic on a normative understanding of the work that principles are supposed to do in these circumstances of disparity. Maybe less of a problem, though, for principles formulated in a way that's supposed to help characterize a given legal system rather than solve cases within it. An unruly characterization is a characterization, after all. And the truth-seeking purpose of legal science may actually be better served by putting these contradictions on explicit display rather than saying decisively in an objective spirit that this is how the system works or that is how the system works. Schultz's enterprise and principles of Roman law would not have been discredited had he acknowledged antagonism among the principles he identified. Often the best characterization is just to say that the system reflects the uneasy coexistence of a plurality of conflicting values. Or sometimes the best we can do is sort of opt for one particular characterization, uncomfortably aware that there are other available characterizations in the ballpark that other scholars might be coming up with. Now, I mooted earlier the idea that once we acknowledge that some principles operate non-normatively, we might find ourselves revisiting the normativity, such as it is, of principles that present themselves as avowedly normative, at least at first glance. Indeed, some of the principles that we are presented with are often thought of as deontologically normative. The principle doesn't just guide my action, it dictates it and it peremptorily displaces any other considerations. Ronnie Dworkin toyed with the idea that principles as such embody a commitment to individual rights, conceived as trumps over utility or over other social goals or policies. But this won't quite do. Although Dworkin cites many rights-based principles, his most famous example, the one we explored on Monday, the principle invoked in Riggs and Palmer, no one should be permitted to profit from his own wrongdoing, is not right-based at all. It's phrased more in terms of duty or rightness and wrongness. Although the wrongdoer's aunts are held to profit from the estate once Elmer Palmer is disqualified. Although the wrongdoer's aunts are held to profit from the estate, this is not by virtue of any right that they are thought to hold. So we need to raise a question mark over the equation of principles with rights. We may say something similar about various constitutional principles, like the separation of powers that I'm going to consider in my third lecture tomorrow. Though some constitutional norms embody rights, and though there's an unhealthy preoccupation with constitutional norms that embody rights compared to structural norms, many of them, such as the separation of powers, are structural in character, and their significance for rights is at most indirect. Still, they count as principles. Granting all this, however, the idea of a principle does have a sort of deontological feel to it, or at least it can convey opposition to aggregated forms of consequentialism, raising the question whether it would be a mistake to talk about the principle of utility or the principle of efficiency, and so on. That's why Dworkin thinks he is entitled to a contrast between principle and policy. But even if such consequentialist norms don't count as principles in some strict sense, they are still capable of playing the kind of role that Dworkin and others envisage for principles in a body of law. By the way, a lot of what Henry Hart and Albert Sachs said about principles could be applied, they say, to policies as well. Principles and policies are closely related, they said, and for many purposes need not be distinguished from each other. It's worth noting also that judges often use policy as the general term for considerations of this broad character. So, for example, they talk about the well-established policy of English law of imposing a more extensive liability on intentional wrongdoers than on careless defendants. They say that's a policy of English law. We could say it's a principle. It doesn't matter. The distinction, I don't think, is important. We know that Dworkin wanted to insist that the normativity of a principle like the one cited in Riggs and Palmer was not the same as the normativity of a rule. A principle did not dictate a result to be simply secured in specified conditions in the way that an enacted rule would do. But Dworkin said that a principle was normative nonetheless, rather in the way that a strong reason might be normative in moral argument. All that is meant when we say that a particular principle is a principle of our law is that the principle is one which officials must take into account, if it is relevant, take into account as a consideration inclining in one direction or another. Repeat, a consideration inclining in one direction or the other, rather than dictating a certain outcome. But what's the relationship between bindingness and this strong inclination? It's tempting to think that detracting from deontic normativity is detracting from normativity as such, but that's not the case. It just means that one has to be more sensitive with other considerations when one deploys principles. It may be difficult to see for oneself how to apply them or how to convince others of their non-conclusory character. Short of the trumping force that rights are supposed to have on Dworkin's account, principles may have little more than the normativity of reasons, a tendency to favour a course of action, counting in something's favour in the way that a reason might count, something to be reckoned with, something to be answered, but not necessarily decisive in its practical bearing. Hart and Sachs thought all of this made it difficult for principles to be straightforwardly normative, at least as far as ordinary people were concerned. In fact, they offered the following quite striking advice in the Legal Process volume. As independent guides to private persons, the utility of principles and policies is obviously minimal. When they are addressed to people without special training or responsibility, they commonly tell too little about what to do, either to be effective in getting it done or to make a penalty seem fair for not doing it. Principles, said Hart and Sachs, are primarily useful as guides to the exercise of a trained and responsible discretion, usually official discretion. That, I think, is a very, very important blurring of the distinction between normative and non-normative, pivoting around the question, normative for whom? That's, with the appropriate training, you might be able to grasp hold of the normativity of a principle. But without that training, it might be dangerous to let you loose in the field that that principle dominates. If the category of persons whose action is supposed to be guided by the principle is a restricted one, one has to ask with some consternation about the rule of law predicament of those whose legal situation is affected, even though it cannot really be guided, even though they cannot really be guided by the norm. How, for example, is Elmer Palmer, boy who murdered his grandfather, how is he supposed to know about the wrongdoing principle? How is it supposed to have been brought to his attention in advance? He would know that murder was wrongdoing, but the rule of law is perhaps also supposed to guide him by ensuring the transparency of the legal consequences attached by statute to that wrongdoing. Saying that the principle is supposed to guide judicial discretion of the judges in Riggs against Palmer is not enough. For the worry about judicial discretion is not that it might be arbitrary in the sense of whimsical, but that it might embody moral ideas or preferences that the judge has, but that are not necessarily shared by all of those affected by his decision, who in any case have not been given notice of their availability. It is a hard and embarrassing question to ask, how was Elmer Palmer supposed to know that no man should profit by his own wrongdoing? As a layperson, as a person whose action is affected and whose situation is affected by that. Finally, in continuing this theme of the blurring of normativity, I want to say something about principles that present a hybrid face. Complex principles that are clearly normative in some aspects, clearly non-normative in other aspects. Clearly normative in some aspects, clearly characterizing principles in other aspects. I teach a course at NYU on the rule of law, and one source of my interest in this topic involves thinking about the normative work, or if any, that the idea of the rule of law does in legal systems like ours. I've already mentioned the rule of law a few times. So let me get some water here. I've already mentioned the rule of law several times today, most importantly a moment ago, in considering the implications of the warning about principles sounded by Henry Hart and Albert Sachs, and wondering about poor old Elmer Palmer. How did he supposed to know that this principle was going to block his inheritance? And also connected with that, I've had an implicit reference to the rule of law and the specific kind of normativity, and in constraints on normativity that the rule of law idea sponsors. The law's function is to guide action. The law needs to be known in advance. It needs to establish reliable expectations. Those aspects of the rule of law are sometimes at odds with the unclarity or contradictions that principles present. Right now, however, and for the last few moments of the lecture, I want to approach the rule of law from a different angle. Let's focus on the rule of law as a principle in its own right. Let's focus on the rule of law as a principle in its own right, not just as a constraint on the way that other principles operate. The rule of law is commonly mentioned as a distinguishing characteristic of our legal system. It is, we are told, one of its most important characteristics. But there's a further question whether it operates as a principle, or something that looks and is cited very much as a principle, whether it has any specific normative work to do within the legal system, guiding people's conduct, or whether it's really better conceived as one of those non-normative characterizing principles that we found in Schultz's book. I am aware of a couple of explicitly normative or quasi-normative uses for the legal idea of the rule of law. The statute that established the Supreme Court of the United Kingdom stated in its first section that nothing in this act is intended to adversely affect the existing constitutional principle of the rule of law. It sounds as though the principle of the rule of law has legal work to do, which the legislative draftsman did not want inadvertently to negate or upset. Section 17 of the same statute prescribes the following as an element of the Lord Chancellor's oath of office. In the office of Lord High Chancellor of Great Britain, I will respect the rule of law, defend the independence of the judiciary, and ensure the provision of resources for the efficient and effective support of the courts, for which I am responsible. Also, in some jurisdictions, notably New Zealand, which is where I come from, the rule of law is presented as part of the content of lawyers' ethical obligations. Every lawyer who provides regulated services, this should be said in a New Zealand accent, every lawyer who provides regulated services must, in the course of his or her practice, comply with the following fundamental obligations: the obligation to uphold the rule of law and to facilitate the administration of justice. Well, that certainly sounds like a normative use of the rule of law, though it's not clear what the normativity is supposed to amount to. And finally, the rule of law can be used to express enthusiasm for or opposition to a particular outcome. If you think of Justice John Paul Stevens's remark at the end of his dissenting opinion in Bush against Gore in the year 2000, do you remember the culmination of the presidential election in recount after recount in Florida? Stevens said this: "Although we may never know with complete certainty the identity of the true winner of this year's presidential election, the identity of the loser is perfectly clear. The loser is the nation's confidence in the judge as an impartial guardian of the rule of law." But since the rule of law was invoked on every side of every issue in this complex case, it didn't help with the decision. To adapt a remark of my friend Stanley Fish, criticising someone's views as an affront to the rule of law was just a fancy jurisprudential way of saying, "Ah, so's your father." So is the rule of law supposed to operate as a Dworkinian principle? I wonder. Forget Dworkin for a moment. Let's go back to Dicey. In his famous discussion of constitutional law in England, Albert Venn Dicey, that great Victorian relic, described the rule of law as an attribute of English institutions, a distinctive characteristic of the English Constitution, and one of two features, the other is parliamentary sovereignty, which have at all times since the Norman conquest characterised the political institutions of England. That's exactly the sort of talk that Schultz was indulging in when he talked about Roman law. The two principles he mentioned, the two principles that Dicey mentioned, rule of law and the sovereignty of Parliament, are not exactly in contradiction, but they jostle up against each other in various ways, and opinions differ as to whether Dicey ever succeeded in his effort to reconcile the two. Certainly the language he used made them sound like Fritz Schultz's characterising principles. On the other hand, Dicey's rule of law has certainly been used in a quasi-evaluative fashion, at least as a matter of political theory. And that's another thing, that something can be normative in law or not normative in law, and normative in political theory and not normative in political theory. We can't assume that the two sets of distinctions necessarily map onto each other. Dicey's rule of law has certainly been used in a quasi-evaluative fashion, at least as a matter of political theory. Dicey himself used it to fuel his laments about the collapse of legality in English politics and institutions. He worried about how long the rule of law would continue to characterise the constitution and the state practice of the United Kingdom. And in his detailed discussion, I hope you will remember this, he came up with 3 sub-principles of the rule of law. In his detailed discussion, he parsed the rule of law into 3 sub-principles. At least one of them, the third, was definitely understood as a characterising principle. Dicey said, "The rule of law may be used as a formula for expressing the fact that with us, the law of the Constitution, the rules which in foreign countries naturally form part of a constitutional code, are not the source but the consequence of the rights of individuals as defined and enforced by the courts." That for us, entitlements and rights are inferred inductively from the remedies offered by the courts rather than deductively from something like a Bill of Rights. This may be about rights, but it doesn't comprise the assertion of any right, and it can't really be regarded as normative in that or any way, except that it tells us, if you want to focus on the right, find the remedy that's available. It's just a contrast between the way we do things in England and the way they're done in France or in Belgium. But the 2 other Diceian principles of the rule of law did appear more normative. No man is punishable or can lawfully be made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. This purports directly to affect what it's permissible for the authorities to do. And also, no man is above the law, and every man, whatever his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. True, the first of these is vague in the various senses that may be attributed to the phrase made to suffer in body or goods. Does it refer only to punishments or to the imposition of any cost or loss? And the second jostles up against reasons that there are for conferring special powers and responsibilities and procedures on the servants of the state. But neither of these points means that the principle cited is not normative. But listen, in 20th century, and so far as I can tell in 21st century jurisprudence, the rule of law has been commonly understood in terms of Lon Fuller's 8 principles of the inner morality of law. Power must be exercised only pursuant to norms that are general, public, prospective, clear, stable, practicable, and so on. These look as though they may be read normatively as instructions to lawmakers, instructions to King Rex, the failed legislator in Fuller's story. And some of them have actually been embodied in constitutional norms in the US Constitution, the Article 1 prohibition on ex post facto laws, for example. Or at least there they were long before Fuller enumerated them. But Fuller's principles do normative work in the law only insofar as they have actually been embodied in constitutional rules. Thus, the rule of law insistence on prospectivity finds only limited expression in the jurisprudence of Article 1 of the US Constitution. And the principle of publicity does very little constitutional work. These seem to be more a matter of Fuller describing certain principles of political theory that ought to dominate the mentality of legislators. Fuller observed that compliance with each of his 8 principles was a matter of degree and that it would be affected by other values operating in the vicinity. The point can be illustrated in more general terms in a consideration of how far the rule of law commits us to predictability in a legal system. Certainly the predictability of law for ordinary subjects is one principle that needs to be taken into consideration. But it faces off against other principles that the rule of law also sponsors, like the principle of procedural due process, or the room that legal process makes available for legal change and high-level argumentation. If I'm empowered to make a high-level argument saying we should, Your Honour, look at this law in this way rather than that way, then I'm being empowered to unsettle the law to that extent. Such procedures are potentially unsettling, but few of us would want to sacrifice them on the altar of legal certainty. So in order to make normative use of the principle of legal certainty, we have to be aware of the balance that is being struck with these other considerations. Look, none of this is supposed to discredit the rule of law, although any work we do with it, normative or non-normative, should acknowledge ongoing debate, sometimes quite cynical debate, about what aspects of our legal system the rule of law heritage validates. I've spent a few years recently tracing ways in which the rule of law takes us beyond an implacable insistence on certainty, predictability, reliance, and the integrity of expectations. I included some of that work in my most recent book called Thoughtfulness and the Rule of Law, suggesting that the legal method promotes a certain form of thoughtfulness that's a little bit at odds with the attempt to get clarity, certainty, and stability. The same principle that tells us how important predictable rules are also tells us about the importance of reason and thoughtfulness in the law. The rule of law calls for certainty, but it also sponsors creative argumentation in the law and respect for parties' elaboration of new ways of looking at things. So there's another instance of looseness in our understanding of an already multifaceted principle. In tomorrow's lecture, tomorrow evening at 6 o'clock, the final lecture in this series, I will focus on a third kind of principle that, as it happens, the rule of law exemplifies. I'll be looking at grand principles of constitutional politics. Grand principles of constitutional politics. Principles like separation of powers, democratic representation, bicameralism, federalism, checks and balances, and, yes, the rule of law. we will see that these principles too have a chameleon-like ability to adapt their formulations for the exigencies of legal and constitutional adversarialism. It's never entirely clear what they mean, and it's never entirely clear what weight they have against other similar principles operating for hegemony within the same principled space. So many of these principles too have a chameleon-like ability to adapt to the exigencies of legal and constitutional adversarialism. Indeed, sometimes to turn themselves inside out in the way that the principle of separation of powers is sometimes turned inside out to mean checks and balances rather than separation of powers. So I'm going to look at the ways in which we use and abuse principles to make our rather shabby political arguments look more solemn and serious, more deontic and more decorous on both sides. And again, the point will not be to discredit the principles, but just to remind us that they are volatile and they are unwieldy, and they don't necessarily guarantee a decisive win for any party that deploys them. But that's it for this afternoon. Thank you very much indeed.